The United States is rewriting its environmental playbook in real time. In a matter of months, the EPA's mission, budget, and enforcement priorities have been recast. And so has the federal government's stance on climate research, environmental justice, and sustainable development. Welcome to This and That About International Law and Sustainability. I'm your host, Shinye. Today, we're looking at where U.S. environmental law stands right now. In October 2025, we'll walk through EPA rollbacks, fossil fuel expansions, and the unraveling of long-standing tools like the NEPA and Clean Water Act. And then we'll ask the question, where does that leave communities? Where does that leave states like California? And what does that mean for the planet? For more than 50 years, modern U.S. environmental law has rested on three pillars: the Clean Air Act, the Clean Water Act, and the National Environmental Policy Act, or NEPA. Together, these laws did two major things. First, they created national baselines for clean air and clean water. Second, they forced the federal government to look before it leaps, to study the environmental consequences of its own actions and disclose them to the public before moving forward. The theory was simple. If the government and industry understood the harm up front, they'll either avoid it or justify it. That is the core procedural environmental protection in the United States, really the world. That framework is now being actively reimagined. Since January 2025, the Trump administration has framed its environmental agenda under a banner called Unleashing American Energy. The stated priority is not pollution control or climate mitigation. It is lowering energy costs, accelerating fossil fuel production, and limiting what the federal government requires from industry. EPA Administrator Lee Zeldin has said openly at that the agency's mission is to lower the cost of buying a car, heating a home, and running a business, alongside unleashing American energy and revitalizing the American auto industry. Yeah, that is unprecedented. Previous administrators have talked about cost-benefit balancing, but no EPA leadership has ever named cost control itself as a major core of the agency. At the same time, the EPA has been changed fundamentally structurally. The Office of Research and Development, the scientific core of the agency, has been dismantled, including shutting down the Research Triangle Park headquarters. The Environmental Justice Office has also been eliminated. And with it, environmental justice is no longer allowed to guide enforcement, penalties, or case initiation, unless a statute explicitly requires it. And this is more than just a couple of things on paper. This is the federal government stepping back from climate work, sunsetting climate-focused programs across the federal government, including the EPA and the Interior, and explicitly describing climate policy as an economic burden on American households, driving a dagger straight into the heart of the climate change religion, in Administrator Zeldin's words. Here's why that matters. For 50 years, under both Republican and Democrat presidents, environmental law assumed that the EPA's job was to prevent or reduce harm to human health and the environment. The international community, including the U.S., made a commitment to reduce environmental degradation by 2030. However, in 2025, only 5 years away from our due date, the stated job of the U.S. Environmental Protection Agency is to reduce regulatory costs, restore fossil production, and to get rid of the religion of climate change. Now, let's talk about some of these changes in detail. Let's start with air. On March 12th, the EPA called a press conference and literally branded it the biggest deregulatory day in U.S. history. I'm not kidding. I couldn't make this up. What that meant in practice was this: the agency announcing it was rewriting or repealing more than 30 Clean Air Act rules all at once. We're talking methane limits on oil and gas, mercury and air toxins, okay, for power plants, interstate air pollution controls, vehicle greenhouse gas standards, all of it on the table for rollback. And then there's this part which almost sounds like satire until you read it, I swear. The EPA set up what critics are calling the email exemption. Under this policy, fossil fuel and power plant operators can email a request to the President of the United States of America asking for a temporary waiver from Clean Air Act pollution limits. And the EPA says this is allowed under Clean Air Act Section 112I4, which lets the agency delay compliance for up to 2 years if meeting the standard is technically infeasible, or there's a claimed national security interest. National security interest. Yes, EPA even circulated a template to help companies request those exemptions. Environmental groups immediately called in an abuse of authority because communities don't get advance notice and can't contest it in real time. So if you're asking, has enforcement actually changed? Yes, this is what that looks like. Now, sometimes I just be tired, y'all. I be tired, y'all. Now let's talk climate. Back in 2009. Look, I'm showing my age right there. Now let's talk climate. Back in 2000, EPA issued what's called the endangerment finding. It said greenhouse gases, CO2, methane, those things, threaten public health and welfare. That single finding is the legal hook, right? That lets the EPA regulate climate pollution from cars, trucks, and power plants under the Clean Air Act. We need that. The current administration has now started the process to repeal that finding. Comments for that ended in September. If they succeed, here's what happens. The EPA no longer has to set greenhouse gas standards for vehicles. EPA loses the main legal basis to control CO2 from power plants. And climate regulation at the federal level basically collapses unless Congress steps in, which it has not, and I doubt it will. But the goal is clear. Cut climate out of EPA's mandate and redefine greenhouse gases as something EPA doesn't have to treat as dangerous. At the same time, the White House signed Executive Order 14162, putting America first in international environmental agreements, and withdrew the United States from the Paris Agreement. Again, the order also halts U.S. financial commitments under the UN climate system, and the withdrawal becomes effective January 27, 2026. So on climate, the strategy is twofold. Pull out of international agreements and pull back domestic regulation. So let's move on to the next depressing topic. Water, y'all, because water is life, and this hits home for everyone. PFAS, the so-called forever chemicals we've all heard about, build up in the body and have been linked to cancers, reproductive harms, and immune problems. So the prior administration was moving to set national discharge limits and treat PFAS, forever chemicals, as something the federal government had to police everywhere. That's been reversed. The Trump EPA rescinded the proposed forever chemicals discharge standards and basically said states can handle this on their own. Y'all got it. At the same time, EPA has de-emphasized federal enforcement under the Clean Water Act when the enforcement would unduly burden energy production. Inspectors have effectively been told not to shut down or significantly disrupt fossil energy or power generation unless there's an imminent threat to human health or an explicit legal requirement to act. So, two moves. You loosen federal controls over forever chemicals, and you scale back water enforcement that could slow fossil fuel production. That's awesome. Really in line with our sustainable development goals. Now, finally, let's talk about chemicals. So under the Safe Drinking Water Act, the previous EPA proposed federal limits on 6 forever chemicals in drinking water. The new administration rolled that back. It dropped proposed limits for 4 of them entirely and pushed compliance on the other 2 out to 2031, calling it common sense flexibility. And under the TSCA, or the main federal toxins law, EPA has slowed or paused major risk rules. So companies have longer before they have to hand over data on what they've made and where it went. So what does that mean in plain English? It buys time for the industry, and it delays when EPA gets the facts it would need to tighten controls on those chemicals and protect citizens like me. Now, EPA will still tell you it's enforcing pesticide law, taking about 100 actions in 100 days is what they say, especially around illegal pesticide shipments. And that's true. But we also know the agency is facing staffing cuts and a shrinking budget going into year 2026, which will affect its ability to inspect and follow through at scale on a long-term basis. So to zoom out, air rules are being rewritten to favor fossil energy, climate regulations being disassembled at the root, water protections and chemical limits are being delayed or handed to states. The federal science and enforcement capacity behind all of this is being thinned or eliminated, and I'm losing my mind. And that is how you shift national environmental policy in under a year. For decades, one national rulebook made that process uniform. The Council on Environmental Quality, or CEQ, issued binding NEPA regulations for every agency, requiring them to analyze cumulative impacts, connected actions, and reasonable alternatives, and to include public participation as a core step. That was before. Here's the after. In January 2025, Executive Order 14154 revoked the Carter-era delegation that empowered CEQ to prescribe a single binding set of NEPA regulations. And now agencies are instead directed to rely on and revise their own NEPA procedures. Current guidance emphasizes scoping to reasonably foreseeable effects and adherence to statutory page/time targets, with less emphasis on program level cumulative effects narratives unless required by other law. Agencies are being told to narrow their focus. Look only at reasonably foreseeable direct impacts, drop cumulative impact and environmental justice analyses unless another law requires them, and fast track reviews to meet strict deadlines. They can even let project sponsors, the developers themselves, draft large parts of their own environmental assessments or impact statements. The Department of Energy has already moved that way. So instead of a single national process where the public can review, comment, and challenge federal projects, we now have a dozen mini processes designed to move projects faster and silence the cumulative picture of harm NEPA was built to expose. So you might be asking, well, we also have a federal court system. What is the courts? What are the courts saying in all of this? Well, let's talk about the courts, because the courts are a part of reshaping the rules, not just reacting to policy. In 2025, the Supreme Court decided 7-county infrastructure coalition versus Eagle County. Challengers said the agency had to analyze broader upstream drilling and downstream refining impacts. The court unanimously disagreed and doubled down on 2 points. NEPA is procedural, not substantive, and agencies need only analyze direct, reasonably foreseeable effects of the specific project they approve, not speculative upstream or downstream effects, so long as the agency's scope sits within a broad zone of reasonableness. And why does that land different in 2025? Because for 4 decades, if a statute was ambiguous or an expert agency chose a reasonable reading, usually deferred. The Chevron era. NEPA disputes were screened through the APA's arbitrary and capricious standard. Did the agency take a hard look, consider relevant factors, and explain itself without judges substituting their policy views? Courts also accepted agency discretion on scope, when to do programmatic versus project level reviews, and how to tier analysis. In 2024, the court ended automatic Chevron deference. Ambiguity no longer means agency wins if reasonable. Judges now give the final word on ambiguous statutory text. That shift invites narrow text first readings and has already been invoked to par back long-standing protections. Agencies still make clear the APA's reasonableness bar, but they can't count on Chevron to carry the day. Post Loper Bright, the court's 7-county opinion tells agencies a narrow, direct effects EIS is enough if it's within a broad band of reasonableness. That maps directly onto the 2025 executive order and the CEQA pivot. CEQA told agencies to drop cumulative impact and environmental justice analyses. Narrow, major federal action focuses on foreseeable effects, meet strict page limits, and even use sponsor-prepared documents. The Department of Energy has already moved that way. So instead of a single national process where the public can review, comment, and challenge federal projects, we now have a dozen mini processes designed to move projects faster and silence the cumulative picture of harm NEPA was built to expose. Bottom line, pre-2024, Chevron meant expert-led elasticity, plus APA guardrails. Post Loper Bright, Congress or judges call the meaningful shots, not experts. And in 2025, 7 counties signals that a tight direct effects NEPA will be upheld if reasonably scoped. One more layer to all of this is the international floor. In July 2025, the International Court of Justice issued an advisory opinion that states countries have a due diligence duty under international and human rights law to prevent activities within their control from causing significant greenhouse gas emissions that could harm other countries or future generations, using the best available science and all appropriate measures. While an advisory opinion is not binding, it's not binding itself, it is strong evidence of customary international law, which becomes binding on all countries regardless of agreement. So these rollbacks collectively shrink federal government's role in protecting air, water, and ecosystems, shifting power to states already strained for capacity. And without federal environmental justice tools like the environmental justice screen or cumulative impact review, the burden falls hardest on low-income and indigenous communities. States such as California and New York are racing to fill the gaps, invoking state constitutional environmental rights and cooperative federalism carve-outs to preserve stricter standards. Something you can do to stay informed and participate is to go to the EPA.gov and subscribe. Go to regulations.gov and subscribe. Stay abreast of what's going on and participate in the public comment periods. Things are moving fast. We have to stay diligent. The laws that built modern environmental protection are being entirely rewritten, but their story isn't over yet. Courts, states, and communities are already testing how far the pendulum will swing. If you learned something insightful, please like and subscribe. Until next time.